SJC-13613, Cumberland Farms, Inc. versus Town of Braintree Board of Health.
Okay, Attorney Dunlop, whenever you're ready.
May it please the court. Joshua Dunlap on behalf of Cumberland Farms. This appeal presents two questions of first impression. First, what is the meaning of the phrase offer for sale in Chapter 270, Section 28B? And second, has the legislature granted boards of health any express or implied authority to impose fines via administrative hearing? As a preliminary matter, I'd like to make 2 points regarding these issues. First, the board erred by equating an offer for sale with a mere display of goods.
Oh, that's good. Oh, thank you. I think Justice Bowman was going to say, "Come on." You seem to raise an impossibility defense that they clearly messed up and they put these products out in the open on shelves. And you say because they're not entered in the POS system, it's not an offer for sale. Where's that in the statute?
So this is
Plain meaning of offer for sale.
This is a question of statutory interpretation, and the parties agree in the briefs that making an offer for sale is making goods available in exchange for a price. The
Were
parties
the other
agree.
goods that were behind the register, were those offered for sale?
We don't have anything in the record to the extent that they could be swiped through the POS
How
system yet.
does a convenience store offer something for sale?
They make it available to be purchased, so it is
So
possible
when they
to purchase.
display it on the shelf, is your position that that's not being offered to the average consumer for sale?
There has to be an intent for sale. That's what an offer
So I
is.
go to the local 7-Eleven and I have to figure out the manager's intent as to whether or not I could buy chiclets.
It's not a difficult issue, Your Honor. What you'd do is you'd ask, can I purchase that, or I'd like to purchase that,
So
and then say no.
until I get an answer from the merchant, it's not being offered?
You have to take into account the whole of the facts that are available.
And what is your legal authority for that proposition?
That comes straight from the plain language of the statute, which the parties agree on. Again, it's making a good available in exchange for a
Can
price.
I ask you to turn to your second argument?
Yes, I'd be happy to, Your Honor. So we do raise an argument regarding the ability of the board to impose a fine via administrative hearing.
Can I ask a factual question
Yes.
about this? I understood the judge's decision to say that, I think it was a she, was relying on the 2018, was applying the 2018 regulations because those were the ones that were in effect at the time of the violation. Am I correct on that?
So below, the board only argued that the 2018 regulations apply.
Okay, and is that your view as well, that it's the 2018 regs?
Yes, that is what we argued in our brief.
So I may be misreading the 2018 regs, but I thought that the 2018 regs provide for a $100 fine, not a $1,000 fine.
That's correct, and that
Okay.
goes to part of the issue.
So then let's assume that that part of the decision is just incorrect, that somehow someone mistook that the 2018 regs permitted a $1,000 fine, and in fact, it's only a $100 fine. Let's assume that we were to say only a $100 fine was permitted. What happens to all your other arguments if we make that one correction? Because there, that would be within the $300 administrative fine limit. Does everything else go away?
No.
Why
What
not?
it does, it illustrates that there would then be two avenues for the board to pursue rather than one. So if it's $1,000, they would be limited to pursuing criminal disposition. If it's $100, then they would also be allowed to pursue non-criminal disposition. So in other words, there would be another source for them to pursue a fine, which underlines, in fact, our argument that there is no implied power. It is not necessary for the board to impose fines administratively, because now there are two avenues for them to pursue. And what they did instead was pursue at an administrative hearing that is not authorized by the legislature or in the
But the
board's own.
legislature authorized the state agency to promulgate regulations, right?
They did.
And the agency promulgated regulations that set forth procedural requirements, right?
Yes.
And one of those regulations authorizes the local Board of Health to enforce the anti-flavored tobacco law.
To an extent, in the same manner as, is the language, in the same manner as local rules and regulations are enforced. So what we contend, Your Honor, is that that language is a limitation, a recognition that DPH was not granting a board of authority any powers that it did not already possess. So what the board could do is it could pursue suspension of a fine by administrative hearing. That's a necessary power, so it's an implied power. However, for purposes of imposing fines, they would need to either pursue criminal disposition or non-criminal disposition, depending upon the size of the fine. So that regulation only permits use of previously authorized means of enforcement, again, in the same manner as. And Cumberland Farms' reading gives the entirety of that sentence full meaning. Again, you can utilize an administrative hearing if there's a permit suspension, otherwise at law or in equity, pursuant to criminal or non-criminal disposition.
But what does that "or otherwise at law or inequity" mean?
That's referring to the criminal process. So you can enforce.
So it says each Board of Health, and I'll grant you that it's somewhat ambiguous, each Board of Health may enforce the flavored tobacco law or otherwise at law or in equity.
Correct, through the criminal process. So,
But,
and
so the enforcement of the flavored tobacco law is set forth in these regulations?
it does establish certain procedures. It establishes certain safeguards regarding the hearing process that would apply to permit suspensions. What it doesn't do is grant any new authority to a Board of Health to impose a fine by administrative hearing. Because the department's...
Even though the fine is mandatory under the state statute and then also under the state regs?
Correct, because there is a process available to the board.
So the Board of Health can impose a fine that is not allowed by the state statute. That is, the state statute says first offense must pay $1,000, right?
Correct.
Okay, and so you're saying the Board of Health, the local Board of Health, can ignore that mandatory provision because it just doesn't have authority to impose that kind of fine?
No, that's not correct.
Okay, so what is your argument?
What they can do is they can bring a criminal complaint
Which
and
doesn't-
pursue that $1,000 fine through that process.
Okay, so the only way they can enforce this flavored tobacco law is through the criminal complaint?
If it's over $1,000, yes,
But
because then if it were under...
Isn't it always over $1,000?
Yes,
Okay.
except to the extent that they should have applied a $100 fine, which is what was permitted under the 2018 regulations.
But the local regs can't overrule the state law.
And we haven't argued, I was just acknowledging the justice's question as to whether or not there is some conflict between the $100 allowed in the 2018 regulations and the $1,000 stated in the department's regulations. We have not challenged their authority to pursue a $1,000 fine, but if they do so, it needs to be through the criminal process.
All right, so you're suggesting that the most logical reading and rational reading of these regulations is that the only way the local Board of Health can help the state agency enforce the local flavored tobacco law is by filing a criminal complaint.
And that's because we know that boards have no inherent authority. The case law is clear on that. The board doesn't challenge that point. And so it must be expressly or impliedly granted by the legislature.
And you're saying there's no implied grant by the legislature through the state agency in the language that I just read?
Well, it's implied, to be implied, it has to be necessary or essential. That's this court's language. And it is not necessary to be able
Well,
to
that's for
pursue
the
it.
legislature to authorize the local board of health, right? Here,
Yes.
the legislature has authorized the state agency to promulgate rules.
Well, what I would suggest, Your Honor, is that they did not authorize the department to then turn around and grant additional powers not already granted to the board. So they said that the
Why not?
The department
Why-
could
what-
adopt.
what- Can you, yes, explain to
Certainly.
me why the state agency cannot authorize the local board of health to help police tobacco laws?
They were authorized to adopt procedures to implement the law. And Commonwealth versus Maker makes it very clear that that language is not to be read broadly to confer unfettered authority. So what I would suggest, Your Honor, is that what they did is they went ahead and authorized boards to enforce the tobacco regulations via, and again, the language, but the same manner that local rules and regulations are enforced. So what the department was doing was it was recognizing that there was a pre-existing standard for how boards are to impose fines. And if it's over $1,000, that has to be through criminal process. So the department did not purport in its regulations to give additional powers. And I might suggest, Your Honor, it's important to note that boards were conducting these administrative hearings to impose fines on an ad hoc basis even before the department adopted its regulations, but the board makes no effort to identify any statutory grant other than the department's regulations. So what's clear is that the DPH regulations are just a post hoc justification for an ultra vires act, that the boards were just adopting, applying fines by administrative hearing without having ever been authorized. And now after the fact, they say, oh, well, the DPH regulations are what give us that authority. But they do not. Again, they're constrained to, in the same manner as local rules and regulations are enforced. And that has to be read against this court's very clear construct about how a board gets any authority at all. And that's from the legislature directly, either expressly or impliedly, and that is by necessity. And there's no necessity here because there are other procedures available to the board. I would suggest, Your Honors, that Burlington Sand and Gravel and Maroney are both very helpful guides for this court, because in those cases, the board attempted to impose a fine via some means other than criminal process or non-criminal disposition. In those cases, they attempted to collect a fine via a counterclaim. And the Court of Appeals looked at this very issue and said, is the power to impose a fine administratively necessarily implied? And the court said, no, it wasn't, because the town can utilize these other available procedures. So I think both Burlington Sand and Gravel and Maroney are very, very helpful
How about
cases.
deference? We've got sort of somewhat poorly drafted language, and the agency obviously thinks that this is permissible and appropriate, and we owe deference to reasonable interpretations here. Is it really an unreasonable interpretation that they can't impose fines without going through the criminal process?
Well, I think, Your Honor, you can measure your deference, and one of the factors that you consider is whether or not it was an interpretation that was offered contemporaneously. This is just the department coming in after the fact and offering this interpretation for the first time in an amicus brief before this court. The department had never previously suggested, had never weighed in one way or the other on what this language meant. And I would suggest, Your Honor, that giving it the reading that the department suggests runs contrary to all of this court's clear precedent about how a Board of Health is authorized to undertake any action whatsoever.
Counsel, before you leave, related to Justice Kafka's question is the substantial evidence issue back to the first issue.
Yes.
There was evidence, and I know you say it was just a layperson's view, but there was testimony from an employee of Cumberland Farms that it was a mess up. And so Justice Wendland asked you, how else would you prove all this? And you said, Well, if there were an employee to come in and say, so it's not just maybe the technical definition you're looking about, whether you could do this under the POS system. You have an employee, and under the substantial evidence framework, why couldn't they rely on that testimony for the issue of whether it was offered for sale?
So an important point, Your Honor, and that is it's a fact finder's decision as to whether or not a violation has occurred, but it is a question of law as to whether or not particular conduct is in fact a violation. And so a layman cannot admit to that legal conclusion. And the example that I would give is this. A fact finder determines whether a statement is fraudulent, but a layperson cannot admit that a true statement is fraud. That's a question of law. That's what happened here. He admitted that conduct, which we contend did not violate the statute, was put up for sale. That goes to the question of law that this court needs to decide. It's not a matter of admission. Thank you.
Thank you. Attorney Smirch.
Good morning, Chief Justice, Associate Justices. May it please the court. Roger Smerridge on behalf of the Town of Braintree Board of Health.
Can you take us through the statutory authority all the way to the fine and track in a linear fashion how we get from point A to point Z?
It's pretty simple, Your Honor.
Okay.
Section 28B says you can't offer a flavored tobacco product for sale. And then it's 28G, 28E says the fines that are in Section 6 apply. Those fines in Section 6 are mandatory. And then Section 28G says...
And those fines are $1,000.
$1,000 for a first offense. That's mandatory. It's not It's not a ceiling. It's not up to. It's $1,000 flat. And then 28G authorizes the Department of Public Health to promulgate procedures, rules, and regulations.
To implement.
And to implement.
But not to enforce. It doesn't say enforce.
Well, I think enforce is part of implementing a statute, Your Honor.
I mean, perhaps.
Okay.
Do you have some authority for that?
Can we get to
I think that's just plain language of what implement means. I think to
Can we continue down my road first?
I'll defer to the justices, however you want to order your questions.
Oh, no,
Good move.
absolutely. Absolutely.
I've got from 28B to 28E to 28G. Continue the journey.
Yeah, from there you go to the regulations that DPH did promulgate, and they set out the procedure. And the language that Justice Wentland identified during my brother's argument, they say that local boards of health may enforce this regulation. And then there's the comma, followed by the or otherwise language regarding other procedures at law or equity. And while I acknowledge that maybe the language wasn't perfect, and if there is any ambiguity, deference is accorded to the Department of Public Health's interpretation, it says that local boards of health may enforce this regulation. And implicit in that is that includes the fines, including the mandatory fines that are restated in the regulation. So I think that's the path. It's not a far one.
So, yeah, why can't they enforce the fines through the criminal process that they're already authorized to do?
They can, but I don't think they're required to, Your
Why
Honor.
not?
Because the regulation says that they're not required to.
No, it says that they can enforce it.
Yes.
And the only mechanism, according to the cases that your opposing counsel has said, are through the criminal complaint, basically.
That would then read the entire procedural part of the regulation out of the regulation. It would cast aside sections 45 and 55.
Those procedures would be available for the state agency to enforce the law. But when it deputizes the local board of health, process, and I'll look this up, apparently is only through the criminal complaint.
I would respectfully disagree, because there are parts of 45 and 55 that refer to the Board of Health and its decision-making. I can get the language out in front of me if we want to go through it, but I believe there are parts of it that say the local board or the department.
May I ask you a question, and maybe I just don't understand the relationship of all of these statutes, but in Chapter 111, Section 239, it says that that and this pertains to the promulgation of regulations by the Department of Public Health. It said the department that the section does not limit, I'm just reading now, shall not limit the right of an appropriate authority in a city or town to adopt rules and regulations as may be necessary, provided, however, that such a rule or regulation shall not conflict with regulations promulgated by the department or state or federal law. Why is a rule that would allow the Board of Health to enforce a fine or collect a fine other than as provided by the statutes, which require that it go through a criminal process above $1,000 or a civil process below is it up to 300?
$100 under
Up
the
to
non-criminal
300,
disposition
right,
statute.
non-criminal disposition statute. Why doesn't your interpretation of what the Department of Health and then in turn the board did, why is that not in conflict with state law?
Because there's nothing in Section 28 or the larger act modernizing tobacco control, of which Chapter 111, Section 239 was a part. I mean, you got to remember, this was comprehensive legislation that included that statute, the addition of Section 28 to Chapter 270, as well as the increasing of the fines in Section 6 from their prior pre-act levels, which were 100, 200, and 300, and thus would have been subject to the
I'm not saying that the amount of the fine is in conflict. I'm saying the root of the mechanism of enforcing it.
Yeah.
How is it that your interpretation of giving a mechanism that just allows the board to directly do it, as opposed to filing some process, either civil or criminal, why is that new process not in conflict with state law?
Because there's nothing in Section 28 or any other general law that I'm aware of that prohibits it. And the analysis when you're looking at the regulations is, the first step is what the regulation does precluded by the law? And here it's not. And I would suggest that because my brother cited to Maroney,
Sorry.
if I may.
Yes, of course.
My brother cited to Maroney. In that case, in addition to the zoning bylaw issue, which Section 7 of the Zoning Act does specifically say what the processes are for enforcing a fine in violation of the zoning bylaw. It also refers to the state building code, because there were building code violations there. And the statute that authorizes enforcement of the building code violations, which is 148A Section 2, as discussed in Maroney, that also specifically sets out what the enforcement mechanism is. Here in Section 28, the legislature was silent on the enforcement mechanism. It left it to the department as part of those procedures, not just regulations, but procedures that it was authorized to promulgate to implement the statute. It left it to the DPH. And given
so
that,
how do we understand that the silence is leaving an open door for them to come up with another mechanism, as opposed to simply an indication that the boards are to use the existing mechanism?
I think if the legislature wanted to say that they were to use and had to use the existing mechanism, the legislature would have said so, like it did in the building code statute that's referenced in Maroney. The second thing, and as this court recognized in Trinell Management versus the Board of Health of Barnstable, the 2003 or 1 decision, which this court recognized the authority that Chapter 111 grants to local boards of health to regulate tobacco use. The legislature, when it was enacting the act modernizing tobacco control in 2019, was operating within that pre-existing context that this court had already laid out and that the legislature had laid out by enacting 111 Section 31, which authorizes local boards of health to implement local regulations concerning the public health. In Trinell Management, this court said that that statute recognizes that it's not just state regulation and enforcement. It can go down to the local level. And with that background in mind, The legislature, when enacting the act in 2019, said, we're going to leave it to DPH. Here's the authorization in 28G. DPH, you decide whether you're going to do all the enforcing, whether local boards of health are going to do the enforcing, whether you're going to work together, and if so, through what procedures.
But what do we do with the statute that says that it's a non-criminal disposition to $300, Chapter 40, Section 21?
21D, Your Honor?
Yeah,
Yeah.
so we have that, which is a specific statute, which may, to your brother's point, have more force than this implicit right to go all the way up to the statutory authority that the Board of Health, that the DPH has.
Again, the legislature has to be assumed that the legislature was acting with that statute in mind when it also, as part of the act, increased the fines. The legislature knew it was taking the fines out of the non-criminal disposition realm. And so, given that, in conjunction with 28G, authorizing DPH to now take the reins and promulgate the procedures, that's where you get that authorization.
So they passed it knowing that there was this bar, and
Yeah.
we assume they know their statutes when they passed it.
Exactly, Your Honor.
Do you agree that the 2018 regulations were the ones that should pertain to this case?
Not in the way I think that you're asking it, Your Honor. The DPH regulations are what pertain to this case. The DPH regulations would apply even if a local board of health did not have a tobacco regulation under 111, Section 31. It's a state law, it's a state mandate, and the DPH issued its regulations, and those are what control. The local regulations can supplement that to the extent that they don't conflict under 665-057. But to your point earlier, Your Honor, if the local board of health here tried to implement a $100 fine for a first offense, that would be a conflict with the state law and the state regulation.
Okay,
So
but
it had to be
it has to
1,000.
be at the time of the offense, correct?
The substantive portions, yes, and the time of the offense, the DPH regulations have been in effect for over 3 years.
That's the sure, but what I'm really just trying to find out is why was this not supposed to be a $100 fine rather than a $1,000 fine?
Because in 2019, the state legislature said it's a $1,000 fine. That's the act. That supersedes everything.
So any enforcement action, any violation, whether it's brought by a Board of Health or the DPH, it's bottom line $1,000.
For a first offense.
For first offense.
Even if the local board has a regulation that says something less or more. Either way, because of the mandatory nature of the fine, a different fine set forth in a local regulation would conflict with the DPH regulation and therefore be preempted. That conflict, preemption, was the exact reason why the Superior Court judge here tossed out the suspension of the sales permit, because that was under the then in effect local regulation, and the state
Are
regulation.
you conceding that was correct?
We have not taken a cross appeal from that, Your Honor.
But are you conceding it was correct?
Yes.
Okay.
I mean, otherwise we would have taken a cross appeal.
You're saying that the local town can't do more than what the state has authorized?
If it's a mandatory penalty, that's correct. I don't think the local town can deviate from a mandatory penalty. If there are no other questions on the regulatory aspect, I do want to briefly touch base on the evidentiary portion. And here, the question came up of intent. We addressed this in the brief a little bit, but to your point, Justice Wentland, the consumer has no way of knowing that the store's purchase of sale technology is going to block this item if that testimony is even credited. And again, it's up to the local board to decide what amount of credibility to give to that testimony. But the consumer has no way of knowing that. They see the shelf behind the register, which again is a DPH regulation. To sell tobacco products, to offer them to sale, they have to be on that shelf behind the register. So the consumer walks into the store and sees an open box of flavored tobacco product on that shelf with all the other products for sale, the consumer is unquestionably left to believe that that is available for purchase. The consumer doesn't have to, ask. The consumer doesn't have to initiate any form of transaction. The statute doesn't require any of that. So I think the arguments that have been presented with respect to the evidence are dubious, but even if there was some reasonable doubt under the Pacheco case, the Conservation Commission versus Pacheco case, the court can't substitute its judgment for the Board of Health. And if there's a reasonably conflicting view between two outcomes based on reasonable evidence, which there is no doubt there
Can
was.
I ask you in your last 30 seconds to address the lack of written findings here?
There was no lack of written findings, Your Honor. The town solicitor's letter was the decision. And I will take this opportunity to differentiate. The regulations say there needs to be an order, there needs to be a hearing, or if it's with a suspension, if it's just a fine, then it's a request for a hearing if the retailer makes it. And then there's a decision. So the order was the notice of violations. The hearing occurred, there's no question about that. And then the decision that the regulations refer to, in this case, happened to be the then town solicitor's letter, which was prompted because the morning after the hearing, Cumberland Farms' general counsel submitted a letter to the town saying, we object to this whole thing, we're appealing, we're taking all of our rights. And the town solicitor responded to that. And in that letter included the reasoning for the board's decision, and included in that letter also a statement reflecting that the regulations allow for judicial review. That judicial review happened here. Cumberland Farms got the suspension of the sales permit reversed because of that judicial review. And given that there was notice, an opportunity to be heard, and an opportunity for judicial review, all elements of due process were satisfied, given that, as this court held recently in the Six Brothers case, the ability to sell tobacco products is not a fundamental right.
Okay.
If there are no other questions, the town will rest on its brief.